Skip ahead to 625 for Texas, or you can stay for Furman. Hello, what's up, everyone? So my case today is Furman versus Georgia with under the Burger Court, which was ruled in 1972. So basically, the gist of this case is that you've got this guy right here, William Henry Furman, who broke into a guy's house and claimed that he accidentally shot him while he was robbing him. And I think one account of him said that he dropped the gun and it fired, and then he told another person that he accidentally shot the gun because his finger slipped. I don't know. It was inconsistent stories, but pretty much he shot and killed a guy, whether purposefully or not, and was sentenced to death. This case was actually combined with Jackson versus Georgia and Branch versus Texas when the Supreme Court reviewed it. Because they were all put to death under the death penalty, and the Supreme Court ruled that the death penalty, as it was implemented right now, was not currently constitutional and put a suspension on it until the states met certain criteria. So they did it on the grounds of the Eighth Amendment because it was cruel and unusual in the way that they were implementing it right now, where there were a lot of cases that the death penalty should not have necessarily been applied. And in this case, in many cases, the death penalty is cruel and unusual, not all the time, and it's not consistently applied for all people throughout all states. So what they basically did was said that they needed that states that it was suspended until states made a clear criteria in which the death penalty applied that was approved. So basically, they didn't like how the death penalty was being done and said you are not allowed to give the death penalty until you make a clear set of rules for when the death penalty is applied, and we like those rules. Then you can have it back. So the main thing is that this is a shift of power from the state courts and the state legislature to make their own rules to the federal courts, and they said, no, actually, we are going to make your rules, or not really make their rules, but tell them what rules to make and force them to make it. So this is a shift of balance from the state legislatures to the federal courts and the federal government. And basically the whole thing was that the courts just did not like how it was being implemented, and the Eighth Amendment applies because of the whole cruel and unusual thing, where not necessarily that the death penalty itself is cruel, but that it kind of depends, and that they need to give more thought to make sure that when the death penalty is applied, it is not a cruel punishment. So that was pretty much the circumstances in which this was done. And one big thing is that this is a burger court case. So while so far this case has seemed very progressive because it's, given more rights to the accused, if you know the burger court, you'll know that it in many ways was very progressive, but in many ways it was also very conservative, because in 1976, 4 years later, we had Gregg versus Georgia, where another man who committed a crime was sentenced to the death penalty, and he was like, nope, you guys can't do that. But then the Supreme Court ruled that Georgia's plan, because many states had made plans and rules for the death penalty, the Supreme Court looked at Georgia's plan and said, yep, we actually like that a lot, and you are allowed to use the death penalty again because we like your plan. So basically they said that, or the Georgia courts had made a plan where they said the punishment is after the conviction. So again, we don't even start talking about the death penalty until we find out if you're guilty or not. Aggravating circumstances, again, this is kind of just like another way of saying a severe crime. But the main thing here is circumstances. So it allows the courts to sort of look at a crime and look at the circumstances, like, yeah, you murdered someone, but what were the circumstances under which you killed someone? Was it horribly intentional? Like, it allows them to look at circumstances and basically to find an excuse to where I can see why the death penalty wouldn't be applied. And then all capital punishment was also approved by the Georgia Supreme Court, which just kind of adds an extra layer where if you are put to death, the Georgia Supreme Court has at least looked at your case and said, yeah, this guy kind of deserves this. This makes sense. Other plans that they approved at this time were Florida, Georgia, and Texas. I know some other states have made ones. I know Rhode Island and New York did. I don't know if or how many other states and which ones had death penalty plans, but the ones that were approved were Florida, Georgia, and Texas. And for the rest of them, they said, "You go back, you got to make new plans." So again, the big themes here are Amendments 8 and 4 were used to suspend the death penalty because cruel and unusual, and again, a big thing is equal protection. The Supreme Courts did not like how all the states collectively had done it, and they said, none of you get this power until you guys can come up with a good way to do it that's fair for everyone. The balance of state and federal power is a big thing. And again, if you're writing an FRQ, a big thing that you can do, these are great examples of the Burger Court and how part of the first case, Furman took power away from the states and gave it to the federal government. They stripped the states of a power and then they gave it back to them. So it's from state to federal and federal to state. Those are two great examples of it. Activism versus restraint, again, a thing of should the Supreme Court get involved? In Furman, the Supreme Court said, nope, we're stepping in, we're making sure we're getting involved, and we are overturning what the lower court said. But then in the Gregg versus Georgia, they were like, nope, we're going to go back and we're going to let everything stand. We're going to be restrained and we're not going to get involved because we think that they've done a good enough job. And obviously, supremacy clause, doesn't matter what all the states do. If the federal government says you all need to make rules about the death penalty, does the Constitution say that? Nope, but it doesn't matter because the federal court said that that's what you do, and you got to follow the rules of the federal court. All right, this is Texas versus Johnson. So the Chief Justice was Rehnquist, and the ruling was in 1989. So as many of you may already know, this is the flag burning case in which Mr. Gregory Lee Johnson was in a protest for the Communist Youth Brigade outside the Republican National Convention in Texas. He burned a flag as part of the protest and was arrested by Texas police and convicted for desecrating a national symbol. It went all the way up to the Texas Supreme Court, who said that arresting him for burning the flag was unconstitutional, and the Supreme Court upheld this decision and said that you have the right under the First Amendment to symbolic speech to burn a flag, which actually, at this time, 48 states, every state other than Wyoming and Alaska, had their own laws. The federal government hadn't gotten involved in this before. They had their own laws prohibiting flag burning. So actually 48 states had to repeal those laws because they were now unconstitutional because of this case. So the law actually changed quite a lot because in 48 states before this, if you had burned a flag, you would have gotten arrested and that would have been the end of it. Basically, the context for this case, a lot of you guys might be thinking, okay, well, they sided with Johnson and gave you the First Amendment right to burn a flag. But isn't this the Rehnquist court? Isn't that a court that takes away civil liberties and is very conservative and gives power back to the government and away from the people? And you'd be right in saying that in that Rehnquist was a very conservative Chief Justice because he actually disagreed with this. He was not the one who wrote the opinion. It was actually Justice Brennan who wrote the majority opinion for this because Rehnquist disagreed. And said that the burning of the flag was, he could have protested in other ways, and that the burning of the flag was fighting words because he was burning a flag and sort of insinuating violence. Whereas Brennan wrote in the majority opinion that 154 that the First Amendment protects flag burning because it is communication. So the main distinction here is whether or not you're communicating something, and he thought that it was pretty clear that through the burning of the flag, he wasn't literally trying to like burn down the US or whatever. He was communicating that he was dissatisfied with the way that the US was, running right now, which was communication, which is protected by the First Amendment. So Rehnquist actually disagreed with this case, and this is one of the few Rehnquist court cases that actually protects personal liberties and is opposite to what you would think of when you think of the Rehnquist court era. So some related cases to this are Shank versus the U.S. because, again, it has to do with freedom of speech. That was sort of the beginning of the whole, that was clear and present danger in which, Shank was told, or Shank or whatever it is, was told that because he was impeding the military by telling people to dodge the draft, that he was a danger to the military and impeding their job and a danger to the government. This was later expanded upon in Chaplinsky versus New Hampshire, where the gist of this court case is that it was the first use of the term fighting words. So if you make a protest or have symbolic speech or do whatever to protest the government, it is okay as long as it's not fighting words, which is you are insinuating violence. Now, if he had burned down the flag and say, "Death to America, I hope the White House ends up like this," that obviously would not have been okay because that is fighting words. And Rehnquist actually went with this, case and used that same verbiage and said that no, this is fighting words. But the rest of five of the justices disagreed and said that no, flag burning, he wasn't, insinuating violence. He was just using it as a means of communication. It was not fighting words. But this is one of the court cases where this was used, and it's an important verbiage because they kind of shift to how much speech you have, whether it's danger or it's violence or whatever. But at this time, it was fighting words, and that was the clear distinction here. So yeah, this court case pretty much just has to do with your right to free speech, what you can and can't do with symbolic freedom of protest or right to protest. And there's Mr. Johnson with his burned flag. And yes, you can burn flags. A state cannot make a law against it. That's unconstitutional for them to do so, as long as you don't burn down a flag and insinuate that you are going to also burn down a government office or government official or something like that. Then that's fine, as long as you are using it as a means of communication to send a message. That is perfectly fine.